the bank robbery has been cleared by the independent panel. But the independent panel said, on this thing of assaulting a member, there's prima facie evidence. Then you're 100% right, Chair. I can't now say, when we are dealing with the assaulting the member, if it so happened that it was at the same bank, you understand what I'm saying? You then say, no, you can't mention anything about the bank. Remember, the independent, that would be absurd. That's not the point I'm making. No, the point I'm making is completely different. I am saying, that's why I took you to the example of one charge, so that conceptually we're on the same page. I'm saying, why would you and the other honorable members, with respect, Chair, assuming the only issue here was the Baloyi matter, let's say, and the independent panel established by this parliament says, in the circumstances, we find that the Baloyi matter does not raise prima facie evidence of incompetence or misconduct. Isn't that, and I'm asking this rhetorically, the end of the matter? It is. It's a question that does not need an answer. So, from that principle, I'm simply saying, when you deal with it, and again, Chair, believe me, I appreciate the engagement, because the engagement assists me in explaining. So don't think that I'm going to say, no, you're interrupting me.
You're also aware that this committee does not rubber stamp the panel's report.
I'm fully aware, but the panel, it doesn't rubber stamp, but the panel is not a football match, meaning signifying nothing. We must be told, that's fine, we're happy. But if the panel was not a sifting mechanism, as your submissions were in court, then it negates what you were saying, Chairperson. For example, by parity of reasoning, it would mean that this committee can say that the public protector is not guilty of anything, but the National Assembly must convene for a 2/3 vote. For what? So, I mean, this is really, this is simple, a simple choice of either we respect the work of the panel and then and deal with the issues that they've taken. By the way, Chairperson, they've taken the trouble to assist this committee by putting something called Annexure A at page 117 of the document. It says, finding in relation to the charges. As related to the charges, the preliminary assessment of the panel as per National Rule 129X1B and CV are that there is prima facie evidence of incompetence in respect of the following charges. Then they list them. And then at 263, as related to the charges in the preliminary assessment of the panel as per NA Rule 129X1B and CV is that there's prima facie evidence of misconduct in respect of the following charges. And then they list them. So all I'm saying is that anything that is not in that list should not be, but it doesn't matter what I say. What I'm really saying is that you need to tell us as a committee which is which, because otherwise we don't know what we're doing here or how far it goes. And those are matters that this committee may want to either take legal advice, or if they feel do it by the vote, it's fine. But whatever decision you make will have clear consequences as to what happens next. The last one, Chair, you know, when a lawyer says finally and lastly, you must be careful. But this is a quick one. Okay. There's a rule about self-incrimination. Sorry. Okay. This one is a small point, I can assure you. It's not as big as the previous point. In terms of the rule against self-incrimination, the panel said, and remember this relates to, and I have not raised, but it relates to the CX matter. You may or may not be aware, Chairperson and honorable members, that that matter is a subject of a criminal case. And we raised this with the panel, and the panel's answer was that, well, you may not be compelled to answer questions in civil proceedings, which these are supposed to be, if there's a pending criminal matter, particularly if you're not compelled to answer that. That's just the law. And it was correct. But the question, it then raises a question, begs a question here, as to whether we're compelled. Can the public protector come here and say, I don't want to answer? I don't think so, because she accounts to Parliament. That's what the Constitution says. So that's another matter on which you might want to get some advice as to whether she will be entitled to refuse to deal with certain issues on the basis that they are subjects of pending criminal proceedings. I'll just leave it there. But the big issue, I mean, that can even be resolved in due course. The big issue is the narrow and wide. Let me just have a note from one of my learned friends. Okay, yes. I'm sorry. Okay, one of these issues I think belongs to the issues that we will deal with our learned friends. The issue of the bundles, which we cannot access and so on. I think that we can deal with at the level of the professionals. But the other issues which are raised by Leonard Junior, Ms. Matlape, is that I've raised this, but she wants to emphasize the fact that her emails were only opened on Thursday. What was the date on Thursday? The 7th. Yes. So Thursday, yes, which was the 7th. That's almost a month from the date of suspension, which was the 9th of June. Okay? So for a month, she couldn't access her emails. She couldn't prepare for this, quite apart from the other side issues that were provoked by Parliament about lawyers and all that. So she has not been able to do that, and that is a difference of the suspension, which you say has nothing to do with you. It does. Her PA was removed, and all sorts of things. And she's not quibbling about that, by the way. She's a very strong and formidable woman. But for anybody to think that in a constitutional democracy, you are allowed, as Parliament, as the Speaker, as the chairperson of this committee, as the President, Nohal, to say, we want to litigate against this person about her alleged unfair suspension. One woman against all these powerful people. But you know what? Let her be shackled, put handcuffs on her back and shackles on her feet, and then let's have a fair boxing match. That is repulsive, because you cannot do that. Why does the Speaker and the chairperson of this committee care or want to interfere with the affairs, internal affairs of the Office of the Public Protector, whether they brief this one or they get this lawyer or that lawyer? Why? What has it got to do with you? Because If that is the case, then let's say, okay, fine, then let's be fair. Let the public protector not be represented, and the speaker will also not have legal representatives, and the honorable chairperson will also not have legal representative. That's a fair field. And the president. Let's all go. Man to woman or man to man or whatever. But you are not allowed, in fairness, to want to shackle the individual, the one solitary woman who's the biblical David against all you Goliaths. And now you say, no, this David must, on top of it being David, she must now be also handcuffed. Is that fair? No, it's not. And this is the conduct of this parliament on behalf of me as a citizen. No, I'm sorry. That conduct cannot be accepted. But we want to put it out there that she has therefore been completely sabotaged, to use the word that Mkhwebane CJ used. She has been sabotaged in preparation for this, and she has been sabotaged in preparation for the 25th and 26th, because you, Chairperson, and the Speaker have said that she must not have lawyers there, or whatever you've said. So that means that you wanted to double shackle her for this process, but also for the court process. Why? The question is why? In whose interest is it that the public protector must not challenge her unfair suspension? Is it in the interest of these honorable members on whose behalf you speak, Chair? No, I would dare say. Is it in the interest of South Africans in general? No. Is it in the interest of fairness and justice? No. In whose interest? Let's ask that question. Is it that she must not investigate the things that she's investigating now? And on top of it, she must not even be allowed to challenge her suspension. In whose interest? It is not, I can assure you, in the interest of the people of this country, or in the interest of democracy, or in the interest of this document. Those are our submissions, Chair, and we will thank you for the indulgence and for the engagement. The rest of the directives are not, unless if Ms. Bauer corrects me, I think that was on the directives, the only issue we wanted to refer to you. Let me just thank you for the note. They sent us a summary. Oh, yes. There's another one, I don't know if it has, the definition of a member. We put a proposal that a member means any duly appointed and qualified person who serves in the Section 194 committee. And that was merely just to differentiate. That it doesn't mean, I know I've never been in Parliament, but I know that... You have been. Yeah, well, not formally. No, that in some committees, members, any member of the NA can come, yeah. It's just to ensure that this one is a special... So
you're raising that in trying to address that?
Yes, that's all, yeah. Then the next one is... You do know that our rules, because the NA is supposed to be... I know, they apply here, yes. Okay. But, well, it's something we have to resolve. We don't know. As I say, we're not coming from a point, unlike the ones where we say we're proposing this. Here, we are under your guidance, yeah. So if anybody can just rock up and ask questions, then so be it. Yeah. Then we'll have to challenge those rules, not you. Yeah. And then we said, 2.5, as qualified in the report of the independent panel. Okay, that's the point I made earlier. Yes. The thing about the 5 days of her announcement, Nas, I don't think we need to refer that.
The issue was she's got to answer questions that's posed to her. And the proposal was that she would have to answer it when she testifies. And I think you wanted to say, well, if she opts not to testify, that she then has to answer those questions 5 days
after.
that day
Yes.
after.
No, I know what I said. I'm just saying, is this an issue we need to refer to the committee or we can resolve?
It's not an issue that I can
Okay,
agree
good.
on.
Then let me raise it, Chair. Yeah. Again, this for me, unless it's a non-issue. One of the rules, 5.7, the draft rules which you have seen, maybe the other members have not seen. Basically, I'm paraphrasing. It says that
Just refer to them as directives.
it's directives.
Separate from the rules.
Yes. I'm sorry.
Yeah.
Yes. One of the directive 5.7 says that the public protector may be asked a question at any point, right? And that she must then, if she so chooses, answer that question within 5 days, right? Unless she indicates that she's not going to give evidence, okay? Which is a fair rule, I think. All we were adding there was to say that it must be 5 days of the question or 5 days of her making the decision whether she's going to testify or not. And that's just to do away with an absurdity where, for example, Honorable Mulder asks a question, then we say, no, we're taking the 5-day rule. And then only in September, she decides that she's not going to testify. Then we say, oh, but my 5 days expired in July. Yeah, that would just be an absurdity. So it's just a gap in the rules. Okay. Then, a ruling of the then there's this issue about dignity and people being treated with dignity, which is a good thing. But then it sounds like it's only the chairperson's decision as to what is dignified or not. We're not comfortable with that.
You don't like that?
No.
Oh, okay.
So we think that there should be some mechanism by which that can be tested. In other words, it should not just be the subjective view of one person, however powerful that person might be. But
Isn't that about chairperson making a ruling?
Yes.
Which happens anyway as a presiding.
Yes.
So you don't want the chairperson to make a ruling?
No. Chairperson,
understand me.
Don't ridicule the point I'm making.
Okay.
Yeah, please. I'm saying, I know about I've been chairperson of many things, I'm sure, as you know. Yeah. So, when you are a chairperson, you can make a ruling, but the question is whether that ruling must be godlike and unchallengeable. Are we together? Yeah. So that's the point I'm making. And what we had proposed, which my learned friends raised a serious concern about, a legitimate one, by the way. We said that a ruling of the chairperson in this regard with reasons shall be final unless it is successfully challenged in another forum. And we have abandoned that last part of the wording because the evidence leaders correctly pointed out that that forum, if it's an internal forum in Parliament, it might be easy. But if it's like a court or whatever, then it means we'll never finish here. Because every time you make a ruling, Honorable Chair, we would then have to go up to the Constitutional Court. Yeah. No, that's not what we had in mind. I just want to put it out there. We simply, and we're leaving it again in your hands, want a mechanism, whatever it is, that might be deadlock breaking if we don't agree with your ruling. That's all. It's quite simple. Okay. Now, this one might be important. We said the evidence. What is the body of evidence? We were suggesting that only if evidence has been directly referred to during the hearing, should it form the body of evidence? By that, again, without being legalistic, we just mean what will be the record? Let's assume there's some court proceedings or whatever. What will we call the record of these proceedings? Will it be the 11,000 pages, I think, by now, of documents? Or will it be the documents that would have been referred to? And again, in court, that's quite a simple. In fact, in court, you don't even have to say this. In court, you have what you call a bundle. So the plaintiff has a bundle, the defendant has a bundle, or sometimes we have something called a joint bundle. But the documents that will make it, so to speak, into the record will be those where witnesses have testified about. The rest, if you put all sorts of letters, they just fall away. Yeah. So that's really the kind of thing to simplify we were alluding to there. Yes, then there's a proposal from the other side to us, which we have not yet considered fully. So while we are considering these other issues, we'll also consider this. They put a clause 6.2, no person, whether evidence leader, member, public, while questioning witness shall impugn the character of that witness unless he or she has a reasonable grounds for doing so. The character of the witness is relevant to the evidence, that's normal. And evidence supporting the claim against the character of the witness has been filed with the secretary of the committee at least 3 days prior to when the witness has been scheduled to give evidence. Let me hasten to say the principle is trite, but is whether you need this cumbersome thing about putting things 3 days before and so on. So I think that's something we can maybe find a formulation that makes us all happy, but we're raising it here. Yeah. Thank you, Chair. Unless if I've left anything out, Ms. Bauer, SC will correct me, but those were the issues that we identified, and we would like the committee to consider the technical issues. But for my part, I would like you to consider the substantive legal issues, particularly the ambit and scope of this gathering. Thank you very much.
Thank you very much, Advocate Mpofu, for tabling all of those issues. I see the hand, maybe before I recognize you, just an apology, I had extended this without any break. I didn't want to break the presentation. It's not that I disregard your own health. I wanted to propose that perhaps we break for lunch now, we come back, and then we raise those issues, given the fact that we would not have had a break. And I will recognize your hand, Honorable Mulder, Honorable Milham, Honorable Hendricks, and Honorable Ngola, in that order. The time now is just 6 minutes after 1. Should be back at 2 o'clock from lunch, and then we resume and take from where Advocate Mpofu left. Is that okay with everybody? And in virtual, you can wait for us until we come back. We don't have a virtual lunch. Thank you. The session is adjourned until 2 o'clock. Thank you, colleagues and members.
Recording stopped.
Thank you, Chairperson. Good afternoon, colleagues. Honourable Public Protector, Advocate Mkhwebane, and your team. This is a different process, and we all understand that. And as is the case with judges, they are not summarily just one day removed. There's a process. The same in terms of Chapter 9 institution situations. So we're all going through this process. Now, I've listened to what Advocate Mpofu said on behalf of the Public Protector. And my concern a little bit is this. There are certain issues and things that have been dealt with, which from my point of view, the evidence leaders cannot deal with. It's not on their terrain. Things with regard to fairness, things with regard to the unbiasedness or the impartiality of the committee or the members and those kind of things. Certain things in terms of the process of Parliament. And because of that, Chairperson, I think some of us will have to interact with the Public Protector's team. I've got 5 short points, and I won't be long. I want to start off with the first point. One of the points that was made by Advocate Mpofu was the question with regard to the fact that the Public Protector needs to be protected. And you referred to a case, and you referred to Chief Justice Mogoeng's pronouncements on that. Am I correct if I say that the case you are referring to was the Nkandla one that dealt with the previous Public Protector, if I'm not mistaken? You didn't indicate which case you referred to, but if I remember correctly, I think it comes from that case, the whole question of remedial action that should be dealt with, etc., etc. But on the same point, if I go a little bit further, if you look at section 181, and you referred specifically to subsection 3, which says that the Public Protector should be protected. But it deals not with the Public Protector, it deals with the institution of the Public Protector. That whole section deals with establishment and governing principles, and it says the following state institutions strengthen. Deals with institutions. Even subsection 3 clearly states other organs of state through legislative and other measures must assist and protect these institutions to ensure independence. And they must be, and then it goes on. It deals with the institution. Now, I would like to argue, and I'm not saying nobody says it's going to happen, but it could be that the removal of a specific individual could also be to protect the institution. Because I heard you arguing to say that the Public Protector must be protected. And she must be protected, and those were the kind of arguments. The point I'm making is, first of all, that section deals with the institutions, and I can absolutely understand, and I don't think anybody disagrees that the institution should be protected. But as I say, protecting the institution may imply the removal of a specific individual. The second point I would like to make was, you referred to section 194(3)(a) on a number of occasions. And you made the point with regard to the fact that the Public Protector was suspended by the President. And you wanted to make the point throughout that this committee cannot stand away from that it doesn't have a direct impact on what we are doing. I think the chairperson pointed out that that is not our prerogative to suspend. And the point you wanted to make was, yes, but the committee is mentioned, etc., etc. First of all, that provision in section 194(3)(a) is a prerogative of the President, not of the committee, not of Parliament, nobody else. The President may suspend under certain circumstances. That's quite clear in that provision. Secondly, you made the point that one should not be the judge in your own case, etc., etc. And I guess you know that. The President is not a member of Parliament. He's not a member of the National Assembly. He will have no say whatsoever when Parliament takes a decision either way. It's not for the President. He's not involved in any case. He's not a judge in that. Maybe the point you wanted to make was that the judge suspended because he's being investigated, etc., etc. But that does not have an effect on the institution of the Public Protector. The institution of the Public Protector may proceed with whatever investigation they would like to make. And then you made the point about fairness. You made it a number of times. Now, the chairperson right from the beginning, in his opening remarks, said, this process will be based on evidence and facts so that there is fairness and rationality. And we've gone through many processes, we've seen many court cases in terms of fairness and rationality. I can assure you that if for whatever reason a decision is taken that you may not like, you will not be able to add fairness as a ground for an appeal. It will not be relevant. I'm just saying that, and you've got to accept that in terms of our processes, we know what fairness and impartiality in that instance means. The third point I would like to make is you referred to a constitutional case, and you said in that case Parliament and the President was found wanting, that they have failed in their duties. You did not mention which case you referred to. I am thinking that you are again referring to the Nkandla case, which were under the previous President and under different circumstances. You did not say that. If you refer to a different case where Parliament and the President failed, maybe you should just enlighten us. The next point I would like to make with regard to the question of the secret ballot. I understand very clearly that you feel strongly about the secret ballot. I guess we will discuss that in the committee, but I'm not under the opinion that it's the task of this committee to make any recommendation in terms of the procedure that Parliament should follow after we've completed our work. It's not for us to decide whether there should be a secret ballot or no secret ballot. It's not a recommendation that we can make. It's not on our agenda. It's not part of our mandate whatsoever. On a last point in a lighter vein, perhaps, Advocate Mpofu, you started off referring to that song, A Cry, A Smile and a Dance. And then you explained to us what you understand in terms of the cry and the smile, but you never said what you understood or what the point was you made with regard to the dance, unless it was when you said you're ready to rock and roll. Thank you.
I didn't get the last part.
It was when Advocate Mpofu said they are ready to rock and roll.
Okay. Thank you, Honorable Melder. Next hand that I've noted. You covered. Okay. Thank you. Honorable Hendricks.
Thank you very much, Honorable Chair. Honorable Chair, I have a quarrel with the view.
You have a quarrel?
I have a quarrel with the view that this committee is engaging in a futile exercise. This is a people's committee appointed by a people's parliament to do the people's job. Don't throw at us Roman law, Dutch law, British colonial law, and etc. We are very happy, as a member of this committee, that there seems to be agreement that what these 20 days is all about is 4 cases of so-called misconduct. I can't understand why we can't zoom on those 4 cases, listen to the versions of both parties, and let this committee write up its report. You know, it costs R1 million a day. Fiscus pays R1 million a day as far as the legal cost is concerned. We've got to look at costs as well. This matter has also dragged for 2 years because a committee like this, they used Roman law, Dutch law, all these kinds of laws to prevent this committee from doing its work. So I hope there won't be any further impediments for the People's Committee to carry on with the job. Listen to the 4 cases of misconduct. I was disappointed when the evidence leader painted a picture of so many misconduct cases, and I thought, and then later on, very satisfied that it's only 4 cases. No mention was made of the thousands of cases that promoted democracy.
You mean the 4 charges?
Now, what I'm saying is that there was reference to many cases that smacked of misconduct, but at the end of the day, the Democratic Alliance put before Parliament 4 cases, and that's what we're dealing with. We're not dealing with all the other cases. What was not mentioned to balance these matters was that the successful cases that didn't go to the High Court, that is not in dispute, that promoted our democracy. Now, I took part in one of those cases when the Public Protector's Office I dealt with 7 people, and eventually the public protector made a visit to Mkhwebane. She came with her high heels. We told her to put on gumboots, because the African child in that part of the far south was living in Shoeveridge, eating in Shoeveridge, and praying in Shoeveridge. And so the public protector, if she remembers, she sat down the mayoress at the time and told her, this is the worst living conditions I've seen in my life. So there wasn't a punitive order. There was some agreement, let's fix the problem. And I had no evidence that the public protector was involved with the work of the other 7 people. So my point, Mr. Chairman, is that these 4 so-called misconduct cases, weren't there a lot of other people involved leading up to the public protector putting a signature to the outcome? Why are they not sitting here? They are part of, I don't want to use the word part of the gang. I'm trying to find another word. But they are part of everything that led up to the public protector making a determination, which is now before us as a case of misconduct. Shouldn't the deputy public protector also be sitting here? She may have been involved, because if 7 people were involved with this case that I personally lodged in Mkhwebane, I would imagine many other cases, the legwork was certainly not done by the public protector, but by other people. So shouldn't those 4 charges be against the office of the public protector rather than just the public protector? So that is one of the points I would like to raise. The evidence leader also spoke about fair labor practices. Now, I worked in that field. I must have done 1,000 cases in the CCMA when it comes to alternative dispute resolution. So the suspension of the public protector, which has been raised quite at length, that, in my view, doesn't make the cut. Because from a labor relations point of view, it results in job impoverishment and assault on the right to work and human dignity. We've heard from our legal eagles, I hope that's not a derogatory term, that we have an obligation to protect the public protector. So I call on you, Chair, to ask President Ramaphosa to reinstate the public protector so that this Section 194 committee continue its work with honor. I'd like to end there. Thank you very much.
Thank you, Honorable Hendricks. Honorable Kolangola, followed by Honorable Brad Allen.
Thank you very much, Chairperson. Sihlalo ndivumele ndimxele apha kuwe uMr Mpofu njengomkhulu wa uMr Mpofu, Advocate Mpofu, uyasiqatha. But let me take it to this corner. It's just on a lighter note, Advocate Mpofu. He raises a very critical point of the impact of the court judgments into the inquiry. Will they be binding, or will they merely be relevant? But amidst that submission, his submission and his input is majorly reliant on court judgments, on arguments made by judges, whether in a minority or a majority judgment. So, Chair, the second thing is let us officially, as the committee, welcome the evidence leaders or the evidence leader of our committee. I think it's the first time that we have physically interacted with them in a setting of this nature. The third part, Chair, moving forward first, is the emphasis you have made on the issue of that there is no predetermined outcome, which I think Adoken both equally entertain that correctly. I think the importance of you saying that is we're dealing with a matter of public interest. And we must not think that society does not have a view around what is happening. And we have seen political organizations issuing up statements about the process itself. We've seen civic organizations asserting their convictions around this kind of a process. So I think I want to support your sentiment, Chair, that indeed we are officially saying on record as this committee that there is no predetermined outcome. What will determine the outcome is the evidence led and adduced in this inquiry. So we are running an inquiry. It's a fact-finding mission. Chair, the issue which relates to which Advocate Mpofu raised sharply is an issue of that relates to Section 194 to subsection 3 of the Constitution, which relates to the suspension of the Public Protector. And I think you have correctly captured the views of this committee when you said it's a matter that relies with the executive, not the legislative arm of government. And I'm sure Mr. Mpofu, where he's sitting, he knows that would be actually contravening the doctrine of separation of powers if we would want to enter. Yes, indeed, we are mentioned in Section 194, subsection 3, on the basis that the powers given by the Constitution to the President are premised on us, Parliament, resuming the inquiry. That's the context at which we are mentioned in that section of the Constitution. But he equally raises a very correct thing, so at par, and we're on the same level in terms of understanding how are we going to conduct the inquiry. That at what stage do we declare the inquiry to have started? Which is a very critical question I think he has raised. In my point of view, Chair, you'll understand the process. We won't start it, independent panel, speaker, point, blah, 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 go to the National Assembly. Then there is a National Assembly resolution that establishes this kind of inquiry. Then you have got a first meeting of the inquiry that elects the committee chairperson, adopts the program, and adopts the terms of reference. And at that point, would have declared the inquiry to have resumed. Doesn't resume on the basis that witnesses are called a month later. The process would have resumed, Chair. Let me not overemphasize that point. But I think the directives, Chair, the directives, I'm quite happy that they're able. Mr. Mpofu did outline the battle of the legal representation and all that, and the courts, various courts that had to adjudicate into that matter. But I'm glad that the directives, Chair, are actually clarifying the matter of to what extent does the evidence leader participate, and to what extent does the representatives of the Public Protector participate. Because all I can say conclusively, they are saying, although we are going to be assisted by our evidence leader, and the Public Protector going to be assisted by the legal team, but we, the members of Parliament, are not going to usurp our power to hold the Public Protector accountable, as encapsulated in the Constitution, as much as the Public Protector will not usurp her responsibility to account to Parliament as envisaged in the Constitution. So I thought, Chair, I must equally venture into that, because I think it helps to bring us the form of the inquiry we are to conduct. There's an issue, Chair, which I think is either I missed it when the evidence leader was presenting, or else it was not captured. The entire process we are to conclude probably by end September in terms of the program. At the conclusion, we're supposed to have a report. The report that must have findings. Let me leave it there on findings. That as things stand, we have 4 charges that are premised from the motion, that are premised from the independent panel's assessment of the motion. But I think it must stress that if, in terms of the report, the committee in the findings exonerates the public protector and all charges, then that report would be submitted to the National Assembly, of course. But there is a critical matter that when we have 4 charges and you are found guilty on 1 and not guilty on 3, of course, we're not speaking about charges and guilty on a criminal law kind of a context. We are found guilty on 1 charge, but exonerated on 3. It does not mean that the committee would not actually pose recommendations to Parliament that are saying you must completely be exonerated. I'm trying to make a sense of what may be part of the issues that we have to face with as the committee. I think let's equally remember, Mr. Mpofu speaks about, which I think is a very good point, of are we using a narrow approach or a broader approach? Making a comparison of the motion and the independent panel report, which I think, I don't see where the difference is, because it's a synergy of information, it's a processing of information. But nevertheless, Chair, I think in the regulations, in the directions, it is said there that when this process proceeds, the committee may feel that out of an evidence that is submitted to the inquiry by a particular witness, that it must actually make the public protector accountable to that. The process of 5 days and other things are just operations. They are not that much important. So I'm saying, apart from the motion, apart from the independent panel report, we may find some of the things having to be added in what we'll be processing as the committee. I think, generally, we agree with Mr. Mpofu that the chair usually says, Mr. Mpofu, you call it uncharted waters. The chair says it's a virgin territory. It's a virgin territory.
And you like that?
It's a virgin territory, Chair, because it's the first of its kind. We are here to test if this system of government is working. We are to be an example of how are the future generations going to deal with matters of this nature. So we must run, indeed, I agree, a fair, impartial, and credible process, so that we help the system of governance to be able to say, of course, the lessons we're going to learn, all of us, as the inquiry continues. Otherwise, Chair, apart from that, I'm generally fine, and thank you very much.
Thank you, Honorable Ngola. I now recognize Honorable Heron.
Thank you, Chair, and thank you to Ms. Bauer and Mr. Mpofu for the opening comments or opening arguments. There's just 3 areas that I wish to canvass. The first is a comment that Mr. Mpofu made, which I don't think he fully concluded or developed, where he said that the suspension offends against the rule against bias. And I think it would be important for this committee, in considering the extensive inputs from Mr. Mpofu around bias and the suspension, that he concludes that argument, because I don't think it was fully concluded, other than there was reference to a statement that the appearance of bias is too ghastly to contemplate. But I'm missing the link. I wonder if Mr. Mpofu could conclude that. And then on the question of the submission that we're not bound by court judgments, which was really the, I think, the point that the evidence leader was making. Now, I understood the evidence leader to be making really 2 points. One was that explaining the hierarchy of courts in terms of legal precedent, and that we're all obviously bound by a precedent set by a court until such time as a more superior court overturns that. But there's a second aspect which I thought is what the evidence leader was proposing, and that is that we're not going to relitigate the reviews through this process. And so when she said that, when the evidence leader said we're not bound by, that we are bound by the court judgments, my understanding was that she was saying we're not going to reopen those cases to be re-litigated in terms of reviews here, and that we can accept the judgments at face value. As you correctly said, as Mr. Mpofu correctly said, the independent panel said it's a different context. So my understanding, and I would like Mr. Mpofu to perhaps help the committee, is that if the public protector was to bring evidence that disputes some of the adverse personal findings that are in those judgments against the public protector incumbent, that this committee can then consider that evidence regardless of what the court said. I'm not sure if I'm making myself clear, but I'm trying to understand the link and to distinguish what I think the evidence leader was saying. And then finally, I would like to understand Mr. Mpofu's proposal submission regarding the sifting. The process started with a motion with a number of charges. Those charges were supported mostly by judgments and court judgments, and to some lesser extent affidavits. The independent panel then considered all of that, all of the documentary submissions that supported the original motion, and still concluded that there was a prima facie case of incompetence and misconduct, but excluded some of the cases that were presented as supporting those charges. So is Mr. Mpofu suggesting that there is a prima facie case based on the independent panel's ultimate findings in their Annex A, but it excludes some of the cases that were used in support of that recommendation? Thank you, Chair.
Thank you, Honorable Heron. From the virtual, I see the hand of Honorable Sheikh Imam. I now recognize you.
Thank you very much, House Chairperson, and thank you for those briefings that we had. Now, Chairperson, I'm a little bit concerned, particularly, and I think Advocate Mpofu has raised this as well, the independence or objectivity of the committee when we in the media or in the public platform make statements, more in support of wanting to remove the public protector. Now, when anybody does that, it questions the integrity of the committee that is now sitting. So I must agree with that. The second thing is I must agree with is that you cannot be objective or independent, Chairperson, if there is an investigation against you and then you yourself go and suspend someone else. Surely, I think we must be honest about this. It clearly indicates bias in my understanding. So that's the next problem that I have. But I think what is important here, that this process is the first in many processes, which we are now starting to establish whether the public protector, if the term I'm using is correct, is fit to hold office or not. And when we deliberate on this matter, we'll be making recommendations to Parliament, of course, which all of us are, the members are part of, which a decision will be taken. So, I think in a nutshell, we must understand that, and I want clarity on this one, particularly, the entire decision to decide whether the public protector indeed is fit to hold office or not is based on a handful of matters, judgments that were given against him. But at the same time, there is a whole lot of matters that the public protector has been successful, or officer. Now, I'm wondering, I'm trying to understand. On the one hand, here we've got a whole lot of matters that the Public Protector's Office has been successful. There's a minimal number of matters here that she's been unsuccessful. But based on the unsuccessful matters, or the judgments against the matter, is why we are deciding to have this particular sitting on this investigation that is going on in the Senate. And I'm just trying to question. But lastly, I want to ask, is the information going to be made available for matters that the Public Protector has presided over that has been successful, so that when we are going to interrogate these things, we are going to have an objective on both the successes and the failures, so that we'll be able to make an informed decision, on whether it is in the best interest of the Public Protector to be removed or not. I'll stop there. Thank you very much.
Thank you, Honorable Sheikh Imam. I have not seen any other hand on virtual. In case I've missed, is there anybody else who wants to raise something from the virtual? None? Thank you. Now, I think we spend a lot of time in the morning in the opening arguments. I think the members are only reflecting on those. I don't expect the same marathon going forward. I'm now going to recognize Advocate Mpofu. There are a number of issues where perhaps a response is sought, perhaps to be able to focus on those issues without us rewriting the morning session. Advocate Mpofu.
Thank you, Honorable Chair. There's no problem if you call me Honorable. But no, thank you, Chair. You'll be glad to know. Fortunately, there were some overlaps, so I might not address all the issues, but I'll certainly cover the key issues. Let me cut to the chase with Honorable Mulder. Yes, you are right that the references that are made on the duties of the Public Protector come from the EFF versus National Assembly matter, also known as the Nkandla judgment. As I say, it's called the trilogy of cases. They all have nicknames here. It's the Nkandla judgment, or the EFF impeachment, or the secret ballot case. Yeah. But the only point I'll make, Honorable Mulder, because that issue is going to come again at the end, is that it doesn't matter. These are questions of principle. So if the Constitutional Court says the Public Protector must be protected against the powerful, that is true in 2016 as it will be true in 100 years' time. If it says that she's the biblical Goliath, or rather David versus Goliath, that's the reality. Because this is a unique office. That's all the point that was being made in, it's an invention. Actually, we're the only people who call it the Public Protector. And that judgment says that alone speaks volumes. I think that's that we don't call it an ombud or whatever. We call it the Public Protector for a particular reason. So it's the principle. But on your second point about the institution versus the individual, thank you for raising that, because I think there is so much confusion, and I say that with a lot of respect, around that aspect. The institution and the person, in the case of a Public Protector, are inseparable. And that is why there is this hullabaloo that she must not be represented by this and that and so on, because there's a complete misunderstanding of that fact. The institution, okay, is, if you go to Section 5 of the Public Protector Act, it talks about a juristic person. That's the institution, okay? But the human being, the person, is the public protector. And this goes only for 2 of the Chapter 9 institutions. With all the other Chapter 9 institutions, is the chairperson or whatever of the commission, or the commission, which means the institution. But when it comes to the public protector and the AG, it's the person, all right? You'll find that in Section 194, 193, with subsection. I'll just read the first part because I don't want to debate the section, but just to drive the point I'm making home. So the public protector and the members of the commission established by this chapter must be women or men. Now, what that means is that the public protector and the members of the commission are human beings, we all know. But the public protector is a man or a woman. Now, that's not an institution, cannot be a man or a woman. It's, and that's why Justice Mkhwebane, in his judgment, says her remedial powers, she must not be sabotaged. It's a person, it's a human being with blood, human flesh and blood. Yeah. So, but it's a debate. We will deal with it in another context. And if you are interested, when on the 25th and 26th, when we are in court defending ourselves against the chairperson and the speaker about legal representation,
I'm happy that it's a DNA of this process.
we will explain that. Yeah, but. The quickest, the shortcut to this, Honorable Mulder, is Section 195, the security of tenure section. Is it 195 or 194? No, it's not one. No, 195 is the one about ethics. That's the president's. It's no, yeah, 189. Tenure, the shortest of those sections in Chapter 9. It says, no, it's not 189. Sorry. 189 is the one of the AG. It's exactly the same as 189. Sorry. Yes, 183. That's, which is 183. It's the same exactly for the AG. For reasons, but by the way, without digressing, the reason why the certification case elevated the public protector and the Auditor General for further protection was exactly because of the kind of work that they do. So this section, literally mirror image of it, is one in 190 and one. It says, the public protector is appointed for a non-renewable period of 7 years. So that's simple. That must be a person. The institution cannot be appointed for 7 years. The institution will be there for 2,000 years or whatever. So when this section says the public protector, it actually means literally the person, or the next one, or the next one, or the next one. Okay.
You can note.
Yes, you can. Just so that we.
And it's also a person that is removed.
Yes, exactly. Absolutely. But that's exactly the point. I mean, we had pains to point this out. Unfortunately, it didn't succeed. That you can't say that you are suspending the office. You can't. You are suspending a person who has dignity, who has inherent rights in terms of the Constitution. If you listened to the debate in the last court case, I was at pains to point this out. It didn't assist, but it was to show that there's a case of Masetla, I think, where Justice Sachs said that for incumbents of public office, bread alone is not what it's all about. In other words, the fact that you are suspended with pay is irrelevant because those are people with feelings, and therefore you are rather violating prima facie their human rights. That's the point about. And there can be no doubt that you are correct about the meaning of the word person. Remember in section 194.3a, the one that talks about suspension, the word person appears twice. It says the president may suspend a person at any time after the start of the proceedings of a committee of the National Assembly in respect of the removal of that person. That's exactly word for word what section 194.3a says. So there's no doubt about that. Yeah. The issue of the prerogative of the president, okay, maybe you and I know what you mean, but for the purposes of clarity, there is no such thing as a prerogative. The royal prerogative remains in England for the Queen, who's only second to God, according to them. Yeah. Here, in the real world, whoever you are, even if you are the president or whatever, you are subject to the rule of law. And that was established in the Sarfu case and all that, I'm sure you know that. So that's why I was saying, when it says the president may suspend, that immediately says that it's reviewable. Because we have to say, okay, you had two choices, to suspend or not to suspend. Why did you suspend? Then he'll give his reasons, and then we'll test those reasons for rationality in the usual way. That's what I was trying to explain to the chair. The rule of law means that anyone must justify. It's what Professor Etienne Murenik called this Constitution introduces a culture of justification. So you can never exercise public power which you cannot justify. It's not the other way around. You can't say, no, I'm exercising it, but some are just doing it. You must be able to justify it through the Constitution. So the last point is fairness. Fairness is a concept, and that if I may also charge Honorable Heron's point about the rule against bias, I'll juxtapose that. As I said, fairness has two prongs. It has many other prongs, but in terms of the so-called rules of natural justice, it's right to be heard. Nobody quibbles about that. But what is called the rule against bias has got the following facets. One, you may not prejudge a case. The point that was made by the chair. Two, you may not be a judge in your own cause. In other words, I can't, if you stole my car, I can't be a judge in that case. It's quite obvious. It's a rule of justice. Three, you must recuse, it's called the recusal rule. You must recuse yourself from a decision in which you are conflicted. That's the rule against bias. The lawyers call nemo judex in rem sua. Okay. Now, those three elements are relevant here. Why? Because we are saying you have and it's the point, again, it links with what
Honorable Mola.
Honorable Hendricks was raising about, and I think Sheikh Imam as well. What have we got here, Honorable Heron? We have a situation where a president who was accused of bias in respect of all sorts of things, including the CR17 funding. I'll come back to that. But you have a president who is accused, in respect of whom the ATM puts a motion, I think on the 3rd of June, about the Pala scandal. The public protector I might be wrong with the dates, so forgive me, On the 7th, writes questions to the president, 31 questions. Where was the money? Where were the dollars? What were, and so on and so on. And then on the 8th, she goes public to say, I've released these 31 questions. On the 9th, the president suspends her. The president suspends her a day before the judgment of a court of law in South Africa. If that doesn't make you to be concerned, then nothing ever will. Who does that? There's a judgment tomorrow which is going to determine whether or not you have the power to suspend. But you do it today. No, it must be done today. Why can't you wait 12 hours? The judgment is coming tomorrow. It might vindicate you. In fact, as it happens, it did. But why would you suspend someone who has just given you questions a day earlier than it is legally permissible? When there are 2 court cases in this country that said the former president, Zuma, may not, that's the point I was making. I think it was the chair who interrupted me. Sorry, that's why you were right when you said I didn't finish that point. The former president was prohibited from appointing a judge. A judge. The court said, we argued this, the court said, we know that judges are presumed to be neutral, but it's the appearance. What message does it send to the public? And that goes to your point, which is that it's section 96(2) that is important for purposes. Remember, in the Nkandla judgment, one of the things that we were saying was that the President Zuma had breached section 96(2) and section 181, the one that I spoke about earlier. What does section 96(2) say? It says, unlike you and me and other people, if you are a president or a member of the cabinet, you have even a higher duty in terms of conflict. In other words, you and I might have a conflict if it's my car and what have you. But if you are a member of cabinet, there's an added constitutional duty, which says that members of the cabinet and deputy ministers may not undertake any other paid work, that's another story, but B, act in a way that is inconsistent with their office, or, and this is the important part, honorable members, expose themselves to any situation involving the risk of a conflict. Let me repeat that. Expose themselves to any situation involving the risk of a conflict. Now, for the lawyers in the House, you'll see that's the lowest threshold. It basically says you can't do anything. Expose yourself to anything that shows the risk. And Justice Mkhwebane said that risk doesn't even have to eventuate. It's the risk is sufficient. And that's how President Zuma, that's how we succeeded against President Zuma. Because we said, the judges might be fair, the president himself might actually have no reason to, to choose a pliable judge. But by doing so, he will be exposing himself to the risk of a conflict. And for a president or a member of cabinet, that's sufficient. Was there a risk? If someone sends you questions to investigate you, a policeman comes and says, I'm investigating you tomorrow, and you happen to be the deacon in the church, and then the following day you suspend them in church. It's obvious that there's a risk that you're doing it because they came to your house yesterday to ask you about this, that, and the other. Yeah. So, and that's what Honorable Sheikh Imam is talking about. It's just, one doesn't have to be a lawyer, people. There are just certain things that are so obvious that it should just, your own sense of fairness just should say, And again, the people might have all good motives, but what does it look like to a 2-year-old child? The futile exercise, Honorable Hendricks, if, I don't know if you are directing that to me. If you are, then I must explain. I was certainly not saying that this is a futile exercise. I was saying we must guard against going that way, as the chair was saying. No predetermined outcomes. Let me I'll read you a very short thing. Because we can go through this and then it becomes a complete waste. That's really what the point I was making. This is what the Constitutional Court said about cutting corners. If that motion had succeeded, in other words, a motion like this, let me start. So without knowing whether the Assembly holds the view that the President has committed a serious violation of the Constitution, it would be difficult for him to mount an effective defense. They're making that point. The procedure followed by the Assembly here does not accord with Section 89. You can read Section 194. But here's the important part. If that motion had succeeded, it would not have constituted impeachment and removal of the President as contemplated in Section 89(1). Instead, it would have been an unconstitutional removal of the President from office and would have been liable to be set aside on review. I'm just saying this is what you must avoid. You can go through all this and have a removal up and down and so on, but if it doesn't accord with the Constitution, it will be an unconstitutional removal of the President, read Public Protector, from office and would be liable to be set aside on review. But for the rest, I agree with you, Honourable Member, that part of the evidence, our burden, and I can assure you that we accept it, is to do exactly what you were saying. In other words, we will call the Public Protector, if and when we come to that, to exactly do what you are saying, Honourable Hendricks. How does it work? When the Public Protector says she has done 50,000 investigations since she came into office, does it mean really she did 50,000 herself? And you're quite right, obviously not. There must be layers of investigations that go to her office and others that don't go to. If I have lost my cell phone and my learned friend has taken it and I go to the Public Protector, I'm sure she never even gets to hear about that, and so on and so on. So you're quite right. And we need to drill down to that level. At what point does it come to her? What is the role of the investigators? Does she take their work and say, nah, throw it away and redraft the thing, or not? So that we know where the buck we know stops with her. That, please, we don't even doubt that. But in reality, who is liable, up to what point? I think that's a point that I'm hoping honourable members will take note from what Honourable Hendricks was saying. Yes, someone, let me, Honourable Ngola. No, there's a difference between the binding effect of legal decisions in law and fact, okay? Now, a decision might be binding in law. In other words, the principle, like what I've just said, whether this section or that section applies and so on. And as I said to Honorable Mulder, it doesn't really matter who we're talking, whether it's President Zuma or President Ramaphosa or whatever. When it says the President, it's the President. But, so, decisions of law or legal principles are binding even on other courts, but facts are not binding. I'll explain this maybe through Mr. Ibrahim later, because it's a very crucial point also in relation to how the courts work. Let me give you an example. In the Constitutional Court, you are not allowed to appeal fact. So, in fact, it's actually shocking even to me as a lawyer when you read it. It says, the law there, it says, even if the other court got it so wrong that, if it's only a question of fact, you can't take it to the Constitutional Court, because that court deals with constitutional issues, which are legal issues. So the mere fact that, for example, the public protector, which is peddled along, say didn't appeal a particular judgment, does not mean she agrees with the factual findings. It simply means that there were no legal constitutional points. Sometimes she would have tried, but the court rejected the appeal simply because it's just a matter of fact. So there is a burden upon you to determine the facts afresh, unfortunately. Yeah, someone said something about the doctrine of separation of powers. I think it was you. The doctrine of separation of powers does not mean what is being said here, that the president suspends there and then it's got nothing to do with us. No. The accountability mechanism for the public protector is the National Assembly, right? There's no doubt about that. But the law imposes, or rather gives the duty to suspend to the president. So there already you have a cross-pollination of the executive and the legislature, because the real accountability is here, but the Constitution outsources, so to speak, the suspension function. And therefore, that's why I'm saying it's your business, because you are the accounting authority. Even the president accounts to you, for that matter. So it's a double accountability, cross-pollination. And the doctrine of separation of powers must not be used conveniently. Where was the doctrine of separation of powers when the Speaker wrote to the President to ask him to suspend the public protector? You see,
can I interject a little bit?
That was said. We cannot say things that are not true.
That is not true.
The Speaker asked that the public protector be suspended. Is that what you asked the President?
The letter is on record.
That just now, you've said that.
Okay,
that's wrong.
Okay,
the letter is on record.
Hold back.
There's no such a thing that the Speaker must suspend.
Thank you. No, that remark had the desired effect.
You, Honourable Kola and Honourable Melder.
No, that's good. It had the desired effect. This is the point, honourable members. I demonstrated to you that the Speaker has no obligation, either in the Constitution or in the rules, to write any letter to the President about the so-called starting of the proceedings. Let me tell you plainly, if Ms. Nosiviwe Mkhwebane, the Honourable Speaker of this Parliament, had not written that letter on the 10th of March, we would not be sitting here. She would not be suspended, and so on and so on. I can tell you that as a matter of fact, take it or leave it. But if she had not done that simple act of writing that letter, you and I would not be here. I'd be in Joburg, you would be wherever you are.
Can I get a question, Chair?
Just pause on with it, Honourable Ngola.
Yes, Chair. No, with due respect, no. In terms of the operations of government, there is what we usually call the three heads of state, which usually meet particularly on matters of mutual interest. So would Mr. Mpofu say that is an illegal tribunal? It's a bogus meeting. It's an illegal way of operating in the government systems. It's a question. I'm not saying you're saying
it's
that.
a fair question. It's a fair question. And the short answer is no. There is nothing wrong with the three arms of government meeting or even discussing things. But Honourable Ngola, let me just give you a small example. These things are crucial for a democracy. You remember, I'm sure, on your first day in Parliament, when the Speaker has to be, and the President have to be elected. The Constitution is very clear as to who does the what. The Chief Justice comes to Parliament, and you, honourable members, nominate people. We want this one to be the president, we want this one to be the speaker. And that's all it does, to preside over that, because of what you're saying, separation of powers. So we've seen it. On that day, actually, you have the three people sitting there. You'll have the president, you have the speaker, and you have the chief justice. On every first day of this parliament, you have those three people in the same room. That's not a question that's not a breach of separation of powers. A breach of separation of powers will happen when the president or the speaker says, Chief Justice Mkhwebane, in that case, there's a case about some municipality. We think that you should put Judge Shabalala, and so on. That's a blatant breach of separation of powers. Here, it would happen. It has happened in the sense that, as I say, the speaker, without any authorizing instrument in the rules, in the legislation, or in the constitution, woke up one day on the 10th of March and wrote a letter to the president to say the process envisaged in 194.3a has started. Apart from the fact that that was untrue, as I demonstrated to you earlier, because the process in 194.3a has not started. Anyone really should know that by now. Apart from the fact that it was factually incorrect, it was also intended for one thing and one thing. Why would she write that letter? It is to say the process, and use the words, it has started. Where did she get those words? Section 194.3a. So that's why I say it might not be as literal as you and Honorable Mulder when we were jumping to say, I was saying you must suspend. But tell me why. Why did she write that letter? What got into her on the morning of the 10th of March to write that letter, if it was not to say to the president, it's all systems go, wink, wink, chop her head. And as luck would have, by some miracle, on the 17th of March, the president wrote a letter to the Public Protector, citing, saying, first sentence, I have received a letter from the Speaker, a copy of which is annexed, and you are saying the two things are not connected. A copy of which is annexed here. It says that the process has started. Therefore, it means section 194.3a has kicked out. Therefore, give me reasons in 10 days why I should not suspend you. Exactly how it happened factually. So you can deny and jump and do, but that's actually what happened within the space of 7 days. Do you think the president would have woken up on the 17th and written that letter? Had he not received the letter on the 10th?
I hope Mr. Mpofu won't be offended.
No, just pause, let him complete.
Okay, no, I'm done with that point. I think it's, I can't do any better than that. So, and by the way, we pointed this out to the president to say, firstly, the letter you are relying on is wrong, and pointed out even another reason. We said the proceedings. You see all these linguistic gymnastics here of saying the proceedings started. I hear various versions. Let me ask you a rhetorical question. It means it doesn't require an answer. Can you say an inquiry, let's say the Zondo Commission, can you say that commission has started when there are no terms of reference? Thank you. So, I mean, please, people, you sat here and adopted the terms of reference on the 29th of March, but your chairperson tells us that the process started on the 22nd of February. What is that? How can you start a process, a commission of inquiry, like the Zondo Commission, when there are no evidence leaders? Honorable Ngol, you can't. I know you don't want to answer.
You're directing the chair.
No, I'm sorry. That's why, in fact, that's why I said rhetorical questions. It doesn't recognize. I apologize, Chair. It's rhetorical questions. No, you cannot. These evidence leaders, my colleagues, were appointed by you on the 29th of March, 2022. How on earth can you say that the process started before all those things happened? Really, man? Everybody knows the truth. Everybody. All these people who do this thing, and they know the truth. Exactly. yeah.
I want him to, because I still want to. You have a follow-up later. Just hold back. And I'll still come back at the end.
Thank you, Chair. I'm wrapping up. Yeah. I'm just saying, look, let's not. One doesn't need a law degree to know that you cannot say a process has started when all those things have not happened. You have not even wrapped up your own program. You have not even written to the Public Protector to say, we want your responses. You have not written to the public to invite and you say the process has started. Why? Because we say so. No, it doesn't work like that.
I thought you had concluded that point.
Yeah, well, I thought so too, but I saw it looked like it was not landing here. But no, thank you, Chair, I'll move on. The issue of stare decisis, I think we have. Yes, that was Honorable Pratt. There's just one question. Sifting, yes. The sifting issue, for me at least, is very simple, because it's about establishing a prima facie case at a particular level, which is a filtering mechanism for you, in my estimation at least, for you to then do on whatever there was prima facie evidence. Then you proceed with the next stage. I'll make an example. Criminal Procedure Act, Section 174. If I'm charged with car theft and assault, then at the stage of Section 174 of the Criminal Procedure Act, I then say to the judge, there have been 20 witnesses here. Nobody has ever mentioned me stealing a car. But these people have mentioned the other thing. Therefore, I want to be discharged in terms of Section 174. It's exactly the same words that I used here, prima facie case. The court will then say, yes, what is the point of having this whole trial and lawyers and what, when not a single witness has mentioned you in terms of the car theft? Therefore, I'm discharging you, that's what it's called, in terms of Section 174. But with the other charge, witness so-and-so and witness so-and-so mentioned you, therefore you have a case to answer. Not that you are guilty, but you have a case to answer in respect of that second one. That's all, really. And that's what we're asking you to do, which is, otherwise, what was the point of having the independent panel? Yes, Sheikh Imam mentioned the question of selective judgments. What about the judgments where the public protector was successful? And let me take it one step further, and I promise you I won't elaborate on this. We must look into these things in perspective. Justice Mulder. Honorable Mulder mentioned the issue of the Nkandla judgment. That judgment, we will bring you evidence here, that judgment on its own, because it created a binding effect of remedial action, sparked a new era of litigation. Because before that, the remedial action was not binding. or at least was believed not to be binding. So it was, oh well, she has said this about me, so what? But the minute the remedial action was given legal bite, going back to the prerogative, which is almost judge-like, it's almost like a court order, not quite a court order, but it's binding. Then obviously the culprits and the people now wanted to challenge it. No less than Advocate Mdntv made that very clear, to say people who are now in a new era who are going to have cases left, right, and center, and she was obviously right, because people are now, the binding effect is obviously going to create more litigation. That is why Advocate Mkhwebane's era was then marked by this heightened litigious atmosphere of everyone, including ministers and presidents and what have you, challenging the judgment. This thing that she's accused of legal representation and legal fees is exactly what was predicted by her predecessor, to say now we're going to have to need more money for legal activity because of this new atmosphere. Sheikh Imam said, you cannot be independent if there is an investigation against you. That is the law of South Africa. The other case, the second one that I wanted to mention, was the case, you might remember, of Masana. It something to do with the NPA. There, the court, the same court, said President Zuma cannot, in fact, it's closer to home than even the other one. It said President Zuma cannot participate in the hiring, suspension, and firing of the NDPP in a situation where he's being investigated by that institution. That's obviously correct. But now suddenly we want to forget these things and say that President Cyril Ramaphosa can be investigated for 6. 1, 2, 3, 4, 5, 6. Each one of those is an impeachable offense. Each one can land him out. 1 is the Zimbabwe trip. 2 is so-called judicial capture. 3 is the Busasa matter. 4 is the Mervyn Dex thing about him knowing that people are in the ANC are using public funds and so on. 5 is Glencore, which was a complaint raised by the UDM. 6 is Phala, the big one. Each one of those is an impeachable offense. President Zuma could not act for 1 investigation, but President Ramaphosa can suspend with 6. It's like 6 life sentences facing him. Really? Really? So, and he must do that a day before, when there's a court case coming tomorrow. Let's quickly get rid of her out of and we say, no, it's got nothing to do with us. Thank you, Chair.
Thank you, Advocate Mbofu. Colleagues, I want to go towards wrap up and a summary, but I will give you a quick follow-ups, starting from Honorable Herren, Luzipo, Milham, Honorable Olomisa, Honorable Mulder, a second bite, Honorable Hendricks, and as well as Honorable Gondwe. Quickly in that order, snappy ones.
Thanks, Chair. I will be quick. Perhaps my questions weren't clear enough. The Advocate Mpofu's established perhaps an argument for bias on the part of the President in terms of breaching the rules, the rule against bias. But what I was really asking is, how does that translate to bias on the part of the committee? And then secondly, the question that I don't think was answered was around the value of the court judgments. When you said we're not bound by those judgments, and I was asking, we can take them into account, I assume, as evidence, unless there's evidence that you bring to rebut the findings by the court.
Chair, with your permission, can I just kill that quick?
You want to rush for that one?
Yeah. Yes, just because I'll take 1 second.
Okay.
Go ahead. The one about judgments, I answered when I was answering Honorable Ngola. And so I thought it was covered. I apologize if it wasn't. All I was saying is exactly go to 103.1 of the independent panel. That's really all I'm saying. It says there, in law, they say context is everything. And the panel said, we understand that these judgments were being done in different contexts, so you can't somewhere transplant them into this process. But does that mean, as I said earlier, that they are irrelevant? No, because they are there. And they can be taken into account, as you correctly point. But it doesn't mean that it absolves this committee from going through painstakingly each of those findings. And for itself, not because some court said so, satisfying itself that that is so. Otherwise, there's no point in us being here. We can just give you the judgments to read at home, and then you just give a judgment. But 103.1 of the independent panel report. That's where they explain, we had said to the panel in our representations that they can't be bound by the court cases for the reasons that Honorable Heron was explaining.
Okay.
And that was the response. The first one, what was your first point?
How the bias...
Bias. Oh, yes. No, the rule against bias kicks twice. One, I won't go through that whole thing about the bias of the president. But as far as the bias of the committee is concerned, it's what I call the second leg, what the chair opened with in the morning when we started here, predetermined outcomes. I'm saying that is what this committee has to guard against. In other words, as I said in the morning, if we are here just to confirm what we all know, that this party has got this position and this one has that position, then again, we're wasting the taxpayers' money. Or, what is worse, if we're here, well, not if, since we are here with people who said, imagine Mr. Heron, Honorable Heron, let me give you this example. I'm a judge in your case about whatever. And the day you are charged, I say on television, oh, I'm going to pop champagne now. Would you expect justice from me? No, you don't have to answer that. So that's the point I'm making. If there are people here who have said, she's guilty, she must resign, whatever, all those prejudging comments, then what justice can we expect? But by saying that, I'm not naive to not to understand the fact that there is a political element to this process. If I deny that, I'm not expecting all these people here to be holy, Mother of Mary, or whatever the expression goes. But I expect there to be independence, because I don't believe there's such thing as objectivity. To be independent and open mind, all the things that my learned friend was talking about, because otherwise we are just wasting our time. And the question is, can we then get justice? And that's why I was talking about secret ballot, Honorable Mulder. It was in that context. I do understand that it's not immediately relevant, and as the chair correctly pointed out, it might never even be relevant if there's an exoneration. But the point I'm making is that the UDM case established that even though all the members on day one saw to uphold the Constitution, the reality is that when they have to vote against their own leader, who might be the president, they will not do so. Why? Because they're going to lose their seats, and so on and so on. We all know what happens. And that's why that case established the principle that for the motion of no confidence, I think was the issue in that case, which was had been raised by the UDM. There must be the option of secret ballot, so that the integrity, again, it's not to say the members members of parliament are crooks, or they want to cheat the system. It's just to understand that their duty to the party might sometimes supersede their duty to the constitution, or they might want to play both or whatever. So rather have a system where they vote and we know that there's integrity. And indeed, what happened in that particular vote, for the first time, we had, on my count at least, about 40 or more ANC members who had voted against their own president.
Thank you, Advocate Mpofu, on that note.
Thank you, sorry.
The next, Mr. Honorable Mainland. Luzip.
No, thank you, Chair. And good afternoon. I nearly said good evening. Good afternoon to the honorable members and the team of the Public Protector. I hope, Chair, I won't be messing up your meeting. I listened carefully. I nearly said, why at a risk? To sing in Kunzankomo, city sing mass, but we'll explain one day. I just maybe at a procedural level, because I understand you are dealing with an inquiry. Under normal circumstances, you would get presentation by the evidence leader, subsequently followed by the defendant, whatever you call it. But before that process, whether it's whatever nature of an inquiry, because I can see the advocate where he might be driving, there is something called point and limine. The point and limine raises bases and conditions under which there is an objection or there is something that was amiss before. Now, the reason I was saying is from a procedural point of view, is that I don't get a sense whether in the presentation there is an objection on the process or the procedure. Probably, let me put it up front. The objection is that, one, we don't think from this committee we will get fairness on the following grounds. For an example, already the Speaker of the National Assembly and the chair who is presiding over this meeting have already deposed in opposition to our application. That's why I said, I wonder so that we end up debating when there could be a process after the debate where there is no consensus. Because the advocate says, then there is another process. And when lawyers say there is another process, there is really another process. And we know what is that process. So I just thought maybe if we can keep, so that if there is an objection, then what in that objection, what is deposited? Last point on this one, he then made a comment, he said, the chair cannot make a ruling. Then I then started to be worried that there can be a silent deposition of this objection, and we don't expect the chair to make, because it may not be objective to the process, that he can make a ruling. So if we can deal with that issue so that we know, otherwise under normal circumstances, someone will say, Chair, we are putting an objection, yes, we excuse us that we did not raise it up front, but can we be given an opportunity to raise this point and limine, so that when we move forward, or on the basis of our state of readiness and the failure to address these concerns that we are raising, we may find it very difficult. But I'm sorry if I'm complicating your meeting much more. Thank you very much.
No problem. Those issues are going to be responded to by myself when I summarize the meeting. So you're not out of order. Objections have been registered and specified. We'll respond to those issues. Honorable Mailan.
Thank you, Chairperson. Good afternoon, everybody. Chairperson, just a couple of sort of follow-ups to things that Advocate Mpofu has said. He said earlier that the person and the institution are inseparable. Those were the words that you used.
Sorry, I missed that.
You said that the person of the public protector and the institution are inseparable. My question to you is, in terms of Section 181 of the Constitution, where it talks about other organs of state must assist and protect the institution, does that mean that we as a committee are unable to hold the person accountable? Does that mean that we are unable to find the person competent or incompetent or guilty of misconduct? How does a committee conduct its affairs if the person and the institution are inseparable? So that's the first question. The second relates to the suspension process, and you've gone at length to explain the issues that you have with the suspension process. And my question to you is this: given the terms of reference of this committee, which relates specifically to the charges that have been brought against Advocate Mkhwebane, how can this committee make a finding in regard to a process over which do not relate to those charges? In other words, how can this committee make a finding about the suspension process, which has nothing to do with the evidence before it? Then, just a couple of other things. When you were responding to Honourable Hendricks, you said that the public protector has people working for her and who draft reports, and she signs off on those reports, and ultimately the buck stops with her. And I agree with you on that. But when a court of law calls into question a person's competence for signing off on a report that is legally incorrect, or I think in one of the court cases they used the words legally incoherent, how does that then align with the fact that there are people below that need to take responsibility? How do you justify that when the head of the organization is signing off on that whole process? My last point is also to something that Honourable Hendricks raised, and that was about the fact that there are only 4 cases of misconduct or incompetence referred to here and thousands of cases of good work. And my question is this: do thousands of good deeds outweigh one heinous crime? Let me use an example. If I'm a God-fearing man, I go to church every Sunday, I help little old ladies across the road, I donate to charity, I feed stray animals, but I go home and beat my wife. Does that exclude, or does that excuse my behavior? And so the question is not what good, and that might come in if the advocate is found to be, I don't want to use the word guilty, but do you understand what I'm saying? If she's found guilty of the charges that have been put in this hearing, it might come in as mitigation, but it certainly doesn't exonerate her if that's the case. And that's, I'd like your opinion on that. Thank you, Chair.
Thank you. Next, Honourable Hendricks.
My follow-up is in response to a follow-up, so I hope you will indulge me. We expected this morning to be addressed by Mr. Ibrahim to explain to us what the role of the public protector is, and also the office.
That's coming tomorrow.
That didn't happen.
And it was planned for tomorrow.
Yeah, so that would have helped us in today's proceedings, but I understand there may have been very good reasons. It is all about alternative dispute resolution, and I'm just wondering whether Mr. Ibrahim Wali was chairman of the Constitutional Assembly is the right person to address us on the crux of the whole establishment of this institution, which is an alternative dispute resolution, which debunks what the honourable member have just said previously.
Yeah,
So
we
I
can-
just
we-
want to.
We can park that for tomorrow. We'll be dealing with that issue tomorrow.
So what I'm asking, Mr. Chair, I did write to your secretary that I hope that there would be someone, an expert, that will address us on what is an alternative dispute resolution procedure and why this was the process used for this Chapter 9 institution.
Thank you. Honorable Gonde.
Let me start by greeting everybody. I have, I think, three very brief points. I think I'm covered by Honorable Milam when he talked about separating the office from the person. And I wanted, Advocate Mpofu, I wanted clarity on what you said there, because you said we couldn't separate the person from the office. And then you have section 193 speaking to the removal. So I wasn't entirely clear what point you're trying to make, because then you agreed with what Dr. Mulder said, and then that sort of like made the waters a bit murky for me, but I'm covered by Honorable Milam. The second point I want to make is you've painstakingly gone into the biasness of the president, you know, in terms of suspending the incumbent. And my question is this. I think the president has also pointed out that the fact that he suspended her doesn't mean that the investigations against him stop. And you've gone and talked about the probability and the risk of biasness, etc. And my question is this. Doesn't the fact that the investigations are still continuing, especially the one, you know, around Palapala, you know, they are being conducted by the current incumbent, who's the acting public protector, doesn't that negate or take away that probability and that risk of biasness that you have gone into in great detail today? And then, Chairperson, I think this question is directed towards you around the directives. These directives are in draft form. And I wanted to find out whether we would be taken through them as the committee, because we received them late last night, and you know, and you've just given Advocate Mpofu, you know, a chance to input those directives, and whether we would be taken, you know, through the directives by. I'm not sure if the legal advisors are here today, but and I assume that they're the ones that pen them. But it would be great if we'd be taken through the directives, and we can also get a chance to input them, etc. Thank you so much.
Thank you. Honorable Olamisa.
Thank you very much, Chairperson, colleagues, Public Protector, and Evidence Leader, as well as Honorable, no, he's not Honorable, what is his name? Advocate. I have a little bit of a problem here. And I asked this question right from the start. And I'm not satisfied with the way we understand the meaning of section 1943A. And if we don't clear that hurdle, I'm telling you, we will never finish this inquiry or even start it. What I would suggest we do, because we are still at procedural level, we've wasted a lot of the whole day, and I predict even tomorrow. We are not going to start to argue substantive issues here soon. Let us get a legal opinion to brief us on this 1943A. But don't bring the legal opinions of Parliament, because they have misled us in many cases, which have been won in court. Get a senior counsel to interpret this for us. Because the role of the president and the whole issue which has been raised here around the suspension, it makes some of us uncomfortable. We don't want to be channeled into a tunnel here. We've seen it before. At one stage, we were told in this house that a swimming pool can be a fire pool. Not again. Please, let's get an interpretation of this. There are different views. And let's try and work together as a committee to make sure that we will arrive with a proper decision at the end of the day. But if we, at the beginning, we are still fighting about this, we are not going to go anywhere.
Thank you. Honorable Mulder.
Thank you, Chairperson. I also want to start with section 1943A. And I hear what General Holomisa says, and I understand what he says. For what it's worth, for me, that section is quite clear. And I referred earlier to, I used the word prerogative, and I know we know what it basically means. It simply implicates that the President has the authority, call it whatever you like, the power, the function, doesn't matter, to do certain things. And it says quite clearly he may suspend under certain circumstances. That's what the section basically says. And if I could assist Advocate Mpofu, I would refer you to 84.1. As we stick to the Constitution, it very clearly says the President has the powers entrusted by the Constitution and legislation, including those necessary to perform the functions of head of state and head of the national executive. The Constitution is quite clear. And then the Constitution says he may suspend. Now, whether anybody takes him on review, that's something for anybody else to do. But in terms of the Constitution, he does have that right, and he did that. He exercised that right, that's a fact. And from my perspective, it has no bearing on the work that we are busy with as a committee at this stage. It's got no bearing whatsoever in that respect. And secondly, the second point I would like to make, Chairperson, is that I think if I understand Advocate Mpofu correctly, he wants to argue that we are not bound by the factual findings by the courts in terms of different cases. I think that's actually very wrong. And the reason for that is you referred to the difference between the principles and the facts. Correct. And that's why the Constitutional Court will not deal with the facts, it deals with the constitutional principles. And if there's a dispute on the legal or the factual facts, the Constitutional Court will not apply its mind, but there's other courts. There are high courts. There's the appellate division that will deal with that. I am not aware of any of those facts that are negative for the public protector, that the public protector disagrees with, that have not been appealed against to the highest level of the court who finally makes a finding. Now, if we expect this body to now act as the court of Parliament, it's not going to happen. The evidence leaders this morning very clearly stated, this is not a court of law, it's not a quasi-judicial body, it's not a criminal procedure, but we are bound to take note of those judgments. Those are the factual judgments in terms of certain factual findings. And what we will do is not make a final determination or decision that the public protector should be removed. We will make recommendations to Parliament, who needs in terms of the Constitution to take that kind of decision. Last point, Chairperson. Mr. Advocate Mpofu made a lot of points with regard to the letter of the Speaker, and that is an interpretation. There are, on a quite regular basis, communications going on between the three branches of government. It's normal practice. It's normal practice that Parliament informs the office of the President of certain things that happen in Parliament, and the Presidency informs us of certain things, and the judiciary may also be involved. So I understand from a certain interpretation that this is something strange, this unheard of letter was sent. I think I disagree with that. Thank you, Chairperson.
Thank you, Honorable Mulder.
That's just one point, Chairperson. Just one point. That's precisely why I'm arguing that let's get a legal opinion on this issue. Because this committee is mentioned in section 1943A. That is the interpretation we want. What is the role of this committee vis-a-vis the suspension or the letter written by the Speaker? Please.
Thank you, Honorable Holomisa. You raised that issue up front in the morning, and I'm still going to, as I summarize, get to that. There are two questions from Honorable Mailham and Gondwe that I would like Advocate Mpofu to respond to, and then I will come in.
Before that.
Yes.
It's Honorable Malema.
Yes, go ahead.
I just want to put it on record that I support what General Walomisa said.
Okay. Thank you, Honorable Malema. Honorable Ngwala, before I go to Advocate.
Thank you, Chair. I just want to put it on record that I don't support what Honorable Olomisa was saying. Section 194.3a is very simple and straightforward. It does not need an expert. It's just English, simple English, grade 12 English. Thank you.
Thank you, Honorable Ngola. I did say I'll summarize the issue at the end from the chair. Honorable, Advocate Mpofu on the specific questions raised by Honorable Mailham as well as Kondwe.
Yes, if you allow me, Chair, just to, can I quickly start with Honorable Mulder's points very quickly, just to put him at ease here. As far as Honorable Ngola is concerned, he reminds me there's an English judge who said that the road to law is strewn with, it was a case about Audi, why we need Audi Alteram Partem. It's strewn with cases that look straightforward until they were debated. Yeah. But, so there's no such thing as, the interpretation of a constitutional provision is a very serious matter. As I say, even more than a normal legislation. Because remember, a constitution cannot just be changed willy-nilly. So that's why I said to you in the morning, when the founders, ask yourself when you go home at night, when the founders of the Constitution said of a committee for the removal, what do they mean? And is this a committee for removal? If the answer is yes, then you are right, it's simple. If the answer is no, this is not a committee for removal, but to find the veracity, then I'm afraid it's very complicated. But you'll answer that question for yourself.
We have covered that ground
Yes,
in the morning.
we have. No, I just wanted to clarify that it might be simple for him, but at least not for us as students of the Constitution. Yes, Honorable Mulder, I agree. It's a normal practice. It's like saying that I'm saying that the Chief Justice must not greet the President or whatever. I'm sure they write to each other all the time. The question is, in each particular instance, is it a lawful interaction or not? You can't say, no, because it happened last week, therefore they must do anything. And I think that that's really the point that gets missed. And it's linked to your first point. Believe me, if anything I've said here today gives you the impression that I'm saying that the President doesn't have the power to suspend, then I will apologize. The President is the ordained suspending authority in the Constitution. There's no doubt about that. We are asking you a different question, whether in this instance did he exercise that power lawfully? Because if he exercised it prematurely, it's what is called ultra vires. The court, if the court says, Honorable Mulder, you may suspend Mpofu, but you must do it on a Tuesday. That's what the Constitution says. If sorry, I'm sorry, Chair. So if you do it on a Thursday, it does not mean you don't have that power, but you have done it ultra vires. You have breached the Constitution because the Constitution says you must do it on a Tuesday and you do it on a Thursday. But I'm not questioning your authority so let that be clear. The President is the suspending authority. He has just exceeded his powers, as we say lawyers, because the Constitution tells you you can only do it after the start of the proceedings for the removal. Not on any day that you want, when it suits you, you just wake up and feel, let's suspend the Public Protector. It doesn't work like that. All right. So, Honorable Mayor Ham, okay, I promise you I'm saying this, I won't say it again, yeah, because it sounds as if I'm being repetitive. The fairness, Honorable Mayor, of your duty to fairness to the Public Protector, it extends to the fact that she may or may not have been illegally suspended. Let me simplify it like this. Let's assume we came here and say the Public Protector wanted access to a certain witness so that she can defend herself in this committee. And somebody said, no, you're not going to talk to this witness. Otherwise, we're going to kill you. I'm exaggerating for effect. Then it doesn't make you the murder and robbery squad. But we have a right to come here and say the process that you're about to embark on is going to be unfair because the Public Protector has been denied the normal right of access to a document or a witness or whatever. So when we're saying the issue about the unfair suspension, we're saying it only insofar as it relates to this process. As I said, she hasn't had, because of the suspension, she has not been having access to her computer. These cases, some of them happened in 2015 or whatever. She might think, oh, I sent an email to Mr. Shabalala, which will make it very clear that I did not overreach myself on the CX matter, let's say. But if she cannot access her computer to bring that witness here, then it affects the fairness of your process. Not because you are involved or have anything to do with that blockage, but it has a serious impact on your own process. Yeah. So follow up.
Were there specific incidents that you are referring to? And if so, did you make a request for specific information?
No, Honorable, I'm sorry. It's just an example. Okay. I'm saying to you, it's a bigger point than specific information or whatever. I'm saying the mere fact of the, let me put it like this. Why is Advocate Mkhwebane suspended? Why? 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 Because a suspension in law is to make sure that you don't interfere with an investigation, or that you, and then you must be given a hearing if it's a serious matter, or victimize potential witnesses. Okay? You don't suspend someone just because you can. These charges, we all know, bar COVID, were first put on the 6th of December 2019. She has been sitting in that office until last month. Has the sky fallen? No. The only thing that happened in that 2 years was that she produced 2 clean audits. Right? So, and that's that's not your baby. It goes to the issue of the May. But you have to ask yourself, if you are a fair-minded person, what was this rush that she had to be suspended on the 9th, long before the court case even came out? 12 hours, please. Can't wait for 12 hours just for the court to pronounce. Having waited for 2 years. She has not killed anybody in the office. The only reason was to humiliate her and to attack her dignity and to make sure that she's deprived of legal representation so that she can be burnt at stake and lynched by the lynch mob that is after her. That's all. So that's the point. It's not about a document here or a document there. It's about asking yourself, why was she suspended? Okay. Anyway, your next question was, yes. Yes, okay, yes. Person versus institution. Again, Honorable Member, if I'm saying, I don't want to be obtuse about these things. These are serious matters. When I say this, I'm not saying by any means, that's why I referred Honorable Mulder to Section 5. I know that it's like the president. There's something called the presidency. Okay? That's the office. And then there's the president, the person. Similarly, you'll see there's an affidavit which we submitted last week about this whole thing about the legal representation. And we say there's something called PPSA, right? Public Protector South Africa. You will not find anything like that here. It was a convenience created by her predecessors to try and distinguish the institution from the person. Good thing. Okay? So, and that's the confusion, for example, that is being peddled by some people to say that the Public Protector South Africa is withdrawing as an applicant in her application. Public Protector South Africa is not an applicant. You can't withdraw from an application that you're not an applicant. The applicant is the Public Protector of South Africa. There's only one such person, it's Advocate Mkhwebane, who's the Public Protector. That's why the president of this country, the one who suspended her, to make it clear, when he writes to her, he says, "Dear Public Protector." Now, when you address her, you say Public Protector, because she's the Public Protector. There's no other Public Protector. Okay? And this notion, then again it says, what are we doing here? If indeed she has been removed by the people who say so, then why are we here? Because she's not the Public Protector. She doesn't have a right to challenge anything. But it's that confusion, Honorable Member. It's a very delicate issue. So the institution, yes, it's an institution. But as I say, when you almost have to play it on yourself as to what are we dealing with now. When Justice Mogoeng said she must be, she, meaning Advocate Matonsela at that time, he was using those words interchangeably with the institution. So he was saying she must be protected in terms of Section 181. But the word she, in that sense, meant both the person and the institution. And that's what I meant by inseparable. All these gymnastics out there in the public domain to try and distill, the Public Protector from the Public Protector, from Advocate Mkhwebane, it's just a waste of time, quite frankly, and breath. Because when the Constitution says, even Section 1 of the Public Protector Act says the Public Protector is a person who does this and the other. The other section, which was repealed, said she has the right as to be like any employee. Another section, Section 9 of the Public Protector Act, says that she, like judges, she must not be insulted, otherwise you'll be guilty of contempt, and so on. Now, it doesn't mean, that section doesn't mean you must not come and say, I'm insulting the office of the Public Protector. No, you must not insult the person, just like a judge or a Chief Justice. It is an office, but there's also a person. So those two things are, legally speaking, inseparable, but conceptually separable, because the one is a juristic person, the other one is a human being. Okay.
Thank you.
Sorry.
You're done.
Sorry, I think there's just one. Sorry, oh, it was Honorable Bondo. Sorry, Chair. Okay, yes. Okay, before I come to Honorable Gondwe, yes, the issue about a responsibility. You see, there's a difference between, there are three things that are always confused: liability, responsibility, accountability. Of course, the public protector, as I said, I'm saying this for the second time, is the buck stops with her. Just as the president, the buck stops with him because he is the president. But you cannot really say that you're going to impeach the president because a certain minister robbed a bank. Okay? Which probably happens. Yes, yeah. No, because it's a crime that everyone accepts to be a crime. But, you see, having said that, that point, I can make it against myself as well. You can maybe impeach a president for not firing the bank robber. Now, those are two different things. You accept that the buck stops with that person. But you're not going to find them guilty. That's the point that Honorable Hendricks was trying to make. You can't then hold them for something that somebody else did down there, who reports to them admittedly, until you can create that link. So if you say, for example, as I said earlier, I'm an investigator. I was investigating his malfeasance, and I found that he did this extension. I gave it to the public protector. Public protector said, no, that gentleman is my friend. I'm going to... Then you can say, well, even though it was done by the investigator, she is responsible. We must distinguish between those different issues. I think, Honorable Gondwe, I've also answered your issue about the person versus the institution, but your second question was about yes, is the Twitter's favorite. What does it matter that she's suspended? Because the so-called office continues, and so does the investigation. So says the president as well, by the way, even in his suspension letter. No, it doesn't work like that. The fact that you forget about what's going to happen next. The conflict is at the level, at the point of suspension. Can you suspend a person who is investigating you? Okay? Now, it doesn't mean you are a bad person. Maybe the person deserves the suspension. It's not about maybe the person has killed 1 million people, so they must be suspended. Fine. But are you, as the person who is being investigated by this person, supposed to be the suspending authority? The president of South Africa, said in an affidavit, under oath, sworn to God, when we did the first case, that he is conflicted or potentially conflicted in relation to the Bosasa matter. And therefore, if the Bosasa matter had come, or rather, if 194.3a had come to be invoked while the Bosasa matter was in place, he was going to delegate that to another member of the cabinet. I hope I'm not misquoting him. In terms of Section 90 of the Constitution, the Section 90 of the Constitution says whenever the president is unable to perform his duties, he must delegate to the following hierarchy: the deputy president, a minister appointed by him, the speaker, and so on and so on. Section 90, bracket 1. Okay, so that's what he was going to do. Now, for a person who, and he said,
I hope you'll wrap up.
sorry, I am.
We did cover this ground in the
No,
morning.
no.
Please.
The honourable member, I think, raised an important aspect of it. Thank you, Chair, if you indulge me. What I'm saying is that the President, having accepted that, he said in those papers, correctly, it's what you call as lawyers, confession and avoidance. Yeah. He said, by doing this, by that delegation, I'm not accepting that I'm conflicted. In fact, which is good. But I'm saying, in terms of Section 96(2)(b), the integrity of the office of the President would disallow me from suspending her. That was in respect of one investigation. Now we have 6. Okay? So you can't say whether someone else, in fact, it might even be worse for the President. If I was the Deputy Public Protector, he probably would have preferred to have Advocate Mkhwebane. Maybe I was going to do
Thank you, Advocate.
worse than that. Yeah. But that's not the question. The point I'm making is that firstly, people differ. People differ. We know, for example, now, there's a hullabaloo about the President having been given an extension to answer the Pala questions. Would Advocate Mkhwebane have given him the extension? Maybe. I don't know. But you can't for sure say that she would have given the extension for the same amount of time, for example. It doesn't.
Thank you,
life
Advocate
doesn't
Mpofu.
work like that.
I have no intentions to break your flow, but I think it's...
you've broken it anyway.
The ground is well covered. Thank you.
Thank you.
Honourable members, I just want to, in doing the summary, want to touch on 3 areas. The first is what I call the factual journey of this committee. In case we don't all remember, this committee is established on the 20th of July 2021. That's when I get elected as a chair of this committee. On the 28th of July, this committee, 8 days later, adopts a program. That's on the 28th. A day or 2 thereafter, the Western Cape High Court delivers a judgment in which it then ruled that there's a defect on the issue of legal representation as well as the issue of the judge. Okay, that's our journey. We pause, and I called it a long pause. We paused and we resolved that the Speaker is going to oppose the matter. In fact, appeal. And in which case, the Speaker appealed at the same time both to the SCA and Concord. The Constitutional Court delivers a judgment on the 4th of February, 2022. Mark the journey. 2022 delivers that judgment. This committee meets on the 22nd of February, 2022. In that meeting, having been taken through the actual outcome of that judgment of the Concord, because we also, in the same meeting, Advocate Mpofu, do 2 things. Adopt the terms of reference, and Mayham would have complained about us calling it living. Remember that word? In that meeting, a living document. In the same meeting, a permission is given for the appointment of evidence leaders. This is 22 February 2022. This is the journey of this committee. Now, 10th of March, 12 days later, the Speaker writes a letter, 2022, to the President. That's the Speaker's role. that the committee would have met on the 22nd of February and resumed its work in line with the directive and the judgment of the Constitutional Court, the highest court in the land. So we resumed and we started our work. That's on record. There shouldn't be any dispute about that. On the 17th of March, as Advocate Mpofu refers, the President writes a letter to the Public Protector, which is his constitutional role to do, nothing to do with us as this Section 194 committee. Section 194 is pretty clear on who does what. And since then, every time we ask when this committee meets again, it make the point that that's a suspension that has nothing to do with what we do. We have a constitutional role to play as a committee of the National Assembly, and our task has been very clear from the very beginning. The meeting of the 29th of March dealt with quite a number of other issues. That's not where we appointed the evidence leaders. This is our record. So I want to leave that factual journey of this committee. It's a journey that we record in court everywhere else. While people can have different views about what they understand, those of us who've been here, and there's 36 of us from all 14 parties in this National Assembly who are part of this. And I happen to be the chair of that committee. So that's, I would want us not to make any of those. I think it is the right of the Public Protector, as we respected when she exercised a right in every way when she felt aggrieved and went to court. Because when the Western Cape High Court, a day later after we adopted on the 22nd of February, I mean on the 28th of July, when it delivered a judgment, we had no reason to question it, the timing of it. Why is it delivering its judgment a day after we've met? It's a judicial role. That's their date, that's their timeline, that's their space that they're driving. So that's the first point I thought I must make and indicate here, colleagues. And that all of that we do instructed, directed in line with Section 194. Because we exist in terms of that constitutional clause. Nothing as otherwise would have been called an ad hoc committee. We're not an ad hoc committee. We're a Section 194 for very definite reasons. That's why we are this committee. The second point, colleagues, I want to make, it's in relation to the issue of the directives. In my input when I started here, I said, and I repeat, that I reminded members here that in our last meeting of this committee, I asked for draft directives to be prepared to govern the appearance of persons before the committee. That was done in a committee meeting. And I reported back that has been done. And that I am aware, have been informed, that the Public Protector legal team wishes to address us on this issue, which they did, thankfully to Advocate Dalimbu, because he did say, we're here, in fact started by saying they agree in principle with the directives. Obviously, there are certain areas that they want to register for, so that we're not able, before we issue them, we need to listen to that. They have done that in this meeting, in our presence here. And Advocate Dalim Mpofu took us through those areas where they raised these issues. And I would have said in the morning, after that, we would perhaps overnight and first thing tomorrow to respond and say this is the response to the issues you've raised in terms of the directives, and therefore there's no confusion there. When Thembi Nkosi sent directives to all of you as draft, he did indicate that they remain draft because we wanted you to have an opportunity in this meeting to listen to what is being raised, and that has been done. So I think it's important to make that. I must indicate, therefore, Advocate Mpofu, that we have listened to the specific issues that you have raised with interest and caution, with respect, and we would be able in the morning to indicate in relation to the issues that you have raised about where we're going with these kind of directives. So because that was placed on record, that was raised, we can't avoid that. And so therefore, colleagues, in terms of the next point, because we're here today, the agenda was clear that today was going to be about opening statements and opening remarks. And the day was set out from 10 o'clock to 5 o'clock. We're still within that time when this was set. There was a reason. Others did not understand about, why are you keeping us until 5? I won't mention names, but they did say that. Now you know why. Because part of the fairness and rationality I spoke about at the beginning is that we're going to rush no one. We're going to listen to everybody. Even if I think that the issue that this person is raising is immaterial, because it is about being fair. It is about being rational and traveling along on this particular issue. I've noted when Advocate Mpofu indicated that they are here but under protest, and he did say openly, we will share with you what we're protesting about. Fairly he did in terms of these issues in the directive. On matters, because the directives are in the purview of this committee. That's our product. But matters beyond there's no, I would have given plenty of time for exchanges, to listen to that. But at the end, as I indicated earlier on, and Advocate Mpofu and many members here reflected on that we are not a suspending body. In our meetings, and I want to repeat the point, in our meetings, we would have reiterated the matter that we see the issue of the suspension. It's triggered by our work as part of Section 194. We are not the delegated body to do that. Members, as I explained that, that's the discretion of the president in terms of, as we have been saying here, Section 1943, subsection A. That's his discretion. Ours, as I indicated, is today, tomorrow, and the days to come is marking a new phase of the actual hearing of witnesses. Tomorrow, from 10 o'clock, we will be hearing from the expert witness that you're looking forward to engage. And I can see you've done your homework on the issues that you want to engage with. At 10 o'clock, here to deal with those. Overnight, we have work to do in relation to some of the issues. We also acknowledge, as you even gave us dates about that, very important, that there's still Part B to be attended to by the Western Cape High Court. We'll respect that. That's the 26th, towards the end of 25 and 26 of July. That's a process that, again, we can't interfere with. And that process will not interfere with our work. We're doing our work. And so, colleagues, I would want us, having said all of that, to thank you for your participation and your patience today, and declare that the meeting stands adjourned until 10 o'clock tomorrow. I thank you.
Recording stopped.